A major judicial reform is incoming where Union Cabinet has accepted the proposal to increase the sanction strength of the Supreme Court judges. So the number is going to dial up from 33 Supreme Court judges to 37 Supreme Court judges, and this is going to change that how efficiently our apex court is functioning, how better it delivers, and how it rounds up the whole judiciary system. Hello everyone, welcome to Vajiram and Ravi's Flash News. My name is Shubhangi Singh, and in today's session we are going to discuss in detail and understand that why this reform has been brought in, what it changes, and what more is expected out of this whole judicial system. So as of now, what has happened is that Union Cabinet has accepted the proposal to increase the sanction strength, and for exactly that they have introduced Supreme Court Number of Judges Amendment Bill of 2026. Now once this bill is passed, the existing strength of 33 judges plus CGI will be increased to 37 judges plus CGI. Now this is being done properly based on constitutional norms of Article 124(1), which talks about that Parliament will be responsible for determining the number of Supreme Court judges, and this will be done through legislation. That is why Supreme Court judges number of amendment bill has been brought in. And this is not the first time that it is being done. Over the years, whenever the numbers have been increased, the strength of numbers, be it 1956, it was made 10, 1916, 13. The most recent one was in 2019 when it was increased to 33. It is always implemented through the Supreme Court Number of Judges Act 1956. So the first time it was done through a legislation, and all these other time has been done through amendment to that very legislation. So historically we have seen this expansion, and the whole idea of doing it yet again in 2026 is to address the high amount of pendency of cases that are going on. There is increasingly requirement of constitutional understanding and constitutional litigation cases that we are seeing. And also we have to keep in mind the upcoming retirement of judges, the roster that changes, and most importantly, faster justice delivery system. Justice delayed is justice denied. Yes, we all know that, but how to not delay that justice, how to bring a better efficient system, that is through more manpower, and more manpower is being what is sought through this particular amendment. Now when we are trying to understand that why more judges are needed, first we have understood that there is a massive case blocking. Just to give you an insight that how massive is this, just the pendency in Supreme Court is more than 92,000 cases. The current sanction strength that we have is of 34. That means 33 judges are present, plus then we have CGI. Working strength, as of now we have only around 32, and we are going to see 4 retirements in 2026. So if you look at this number 92,000 divided by 34, you do the math, the number is so huge that it cannot be addressed, and that is causing the delay in justice delivery. Cases remain pending for years, and also the constitutional matters, the constitutional litigation which can help clearing lines, setting the precedent, especially for the lower courts, that also keeps getting postponed year after year. Apart from that, there are certain other challenges in front of us, such as the burden on constitution bench. When we are talking about important constitutional judgments, this is where we need a constitutional bench. That means more than 5 judges. 5 judges bench, 7 judges bench, and then we have 9 judges bench. If we get to see 9 judges at one place, this will directly reduce the availability of judges for their regular hearings, and this requires more time and more expertise. Furthermore, we also have to keep in mind that when we are talking about a number at hand, that can still be tackled, but more is being added to it constantly. How it is being added? Because litigation is at rise. People have better legal awareness, which is absolutely right. They should, and they should use it. But at the same time, we have to understand that it means more cases. welfare rights are increasing, that means more cases if they are not being addressed. Economic and commercial disputes with growth, they do come, that means more cases. And with expansion of economy into realms of digital and its regulation also means more cases. So when we are saying the cases are on rise, increasing at an ever bigger number, this needs to be addressed, the strength needs to be addressed, and that is what is exactly happening through this particular bill. And over the years, we have clearly seen problem that we do not have filling up of sanctioned post. Nearly 29% vacancy rate has been constantly seen when we are talking about High Court level. So, Supreme Court burden, High Court understaffed, then you can round up the judicial system that we are seeing in front of us. So, this is one way of plugging the loophole that is lying right in front of us. Now, what will happen when this bill becomes an act? We will definitely see faster disposal of cases. We will also get to see improved access to justice. Citizens will get benefit because there will be quicker hearings, faster judgments, and litigation costs might also reduce. The constitutional litigation, the constitutional governance, which is an important role of Supreme Court, that will be strengthened because more judges will be able to be part of frequent constitutional bench sittings, and there will be faster and also better education when we are looking at federal disputes, election matters, fundamental rights cases, and overall. Furthermore, when we are looking at bigger strength, you also understand they are coming with their own specializations. They can have this better judicial specialization be in matters of taxes, personal rights, family matters, and so much more, which adds to the judicial understanding and also the whole system and its delivery. And once an efficient judicial system sets up, it not only works in terms of legality, it helps the country's ease of doing business. It helps the contract enforcement across the country and also the investor confidence. So, it also contributes economically. But that doesn't mean that this one thing will solve all our problems. So, let me know in the comment section that what are the problems that are plaguing the current judicial system. Think it as food for thought, write down the pointers. That was all from my side. I will be leaving you here with a prelims practice question. That was some food for thought. That was all from my side. Thank you so much.